Welcome to the presentation From Barriers to Solutions, Investigating and Prosecuting Human Trafficking. My name is Charlie Whitman. I'm an Associate Attorney Advisor at AEquitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's presentation. The presentation will highlight key findings from the Urban Institute's report identifying challenges to improve the investigation and prosecution of state and local human trafficking cases, and offer solutions for overcoming some of the barriers enhancing victim identification and safety and increasing offender accountability through the effective investigation and prosecution of human trafficking cases. Today's presentation, From Barriers to Solutions, Investigating and Prosecuting Human Trafficking, is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, through funding from the U.S. Department of Justice, Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you after the presentation. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. We are joined today by Colleen Owens, Research Associate with the Urban Institute. This presentation was adapted from one Colleen presented to the ABA Task Force on Human Trafficking on November 7, 2012, identifying challenges to improve the investigation and prosecution of state and local human trafficking cases. The Urban Institute is a nonprofit, nonpartisan, social and economic policy research organization whose mission is to gather data, conduct research, evaluate programs, offer technical assistance overseas, and educate Americans on social and economic issues to foster sound public policy and effective government. Today's presenters are Jennifer Long, Director of AEquitas, and Colleen Owens. Prior to joining AEquitas, Jennifer was former director of the National Center for Prosecution of Violence Against Women at the American Prosecutors Research Institute, the Research and Technical Assistance Division of NDAA. And before her appointment as director, she worked as senior attorney at APRI NDAA. Prior to joining APRI, Jennifer served as an assistant district attorney in Philadelphia, Pennsylvania, where she prosecuted cases involving domestic violence, sexual violence, and child physical and sexual abuse. Jennifer has volunteered as an advocate at the Women's Resource Center in Hamilton, Bermuda, where she provided legal services to victims of domestic violence, and served as a child advocate for the Support Center for Child Advocacy in Philadelphia, Pennsylvania. As I mentioned before, Colleen Owens is a research associate at the Urban Institute's Justice Policy Center, where she directs several national and international research projects on human trafficking, spanning 8 countries and 5 continents. Ms. Owens served as Urban Institute Project Director for a National Institute of Justice funded study with the Northeastern University to examine challenges in the investigation and prosecution of state and local cases of human trafficking in 12 counties in the United States. She serves as the Urban Institute Project Director of the National Human Trafficking Reporting System, a joint project with Northeastern University. Ms. Owens is also involved in an NIJ-funded study to estimate the size of the unlawful commercial sex economy in the United States. She served as lead analyst on the GTIP-funded evaluability assessment of anti-trafficking programs in Africa and Asia, and conducted research on changes in federally prosecuted cases of the commercial sexual exploitation of children in the United States since the passage of the CVPA. Today's learning objectives will be to develop an effective collaboration to address human trafficking, overcome barriers to the effective investigation and prosecution of these cases, and identify existing resources and develop strategies to obtain resources critical to supporting human trafficking victims, investigations, and prosecution. I'd now like to turn the floor over to Jennifer and Colleen for the substantive portion of today's webinar.
Thank you, Charlie. First, I'd like to thank AEquitas, specifically Jennifer and Charlie, for inviting me to present today. I should reiterate that this project is a collaborative effort between Northeastern University and Urban Institute. From Northeastern University, the principal investigators were Amy Farrell and Jack McDevitt. They also received research assistance from Stephanie Fahey and Rebecca Pfeffer. On the Urban Institute side, I led the research effort and received research assistance from my colleagues Meredith Dank and William Adams. The goal of our study was to identify characteristics of human trafficking cases investigated in a targeted sample of U.S. counties, and to understand the challenges investigators and prosecutors face in identifying, investigating, and prosecuting human trafficking cases in their jurisdiction. Just to give a little bit of background as to how we designed the study and some of the sort of existing knowledge in the field that led to our study design. In terms of state and local responses to human trafficking, at the time of our study and the time that we did this, 49 states had anti-trafficking laws, though currently with the addition of Wyoming, we now have all states with anti-trafficking laws, but there is still wide variation in the scope of state legislation. Federal funding has gone primarily through task forces to local law enforcement to sort of be the eyes and ears on the ground, since the federal government is limited, and really it's up to local law enforcement to serve as the primary source of identification of human trafficking cases in local communities. Though there have been laws that have been passed, though there has been funding that has been dedicated to task forces across the country, there still have been few cases of human trafficking that have come forward, and there are numerous explanations for that. And this really was the crux of what we were interested in learning about further through our study. So as an example, according to some numbers from the Department of State and Department of Justice, 2009 victims were certified, so those would be foreign national victims, so that does not include U.S. citizen victims of human trafficking. And there have been 531 federal prosecutions of trafficking as of 2010. And there's an even smaller number of state anti-trafficking prosecutions. However, without systematic data collection, we really lack the knowledge of exactly how many cases have been prosecuted on the state level. There have been numerous explanations for this. Some have suggested that we're just not doing enough to enforce the provisions of the TVPA. Others have suggested that there's insufficient coordination among agencies that are responsible for doing the investigation and prosecution of trafficking cases. And still others believe that this is evidence that, the few cases that have come forward, that human trafficking is not a problem in the United States, and that the attention around the issue amounts to a moral panic. Others suggest that there is sort of a failure of organizations to operationalize the law. So that is, there's a lack of awareness by law enforcement about the problem. This is based on research done by our colleagues at Northeastern University and some folks at NORC. There's also failure to designate and train specialized investigative personnel. Again, this comes from findings from an earlier study out of Northeastern University, as well as some other research. So all of this leads to gaps in our understanding. We know that there have been unknown numbers of human trafficking crimes prosecuted. We know that there's no systematic data collection of locally prosecuted human trafficking cases. And there are unknown challenges that exist to state and local prosecution. We know from some of the research that there is evidence that state and county prosecutors lack knowledge about human trafficking even after laws have been passed, and that there's sort of a gap between what we see as laws on the books versus law in action. That is, laws may have been passed, but are those laws being used? And so this really fed into our research design. We wanted to understand the reasons around why so few cases have come forward on the state and local level, and to identify challenges that investigators and prosecutors are encountering in identifying trafficking and investigating and prosecuting human trafficking cases. So our study was guided by 4 main research questions. First, what are the characteristics of identified human trafficking cases? What are the contexts under which certain types of cases move forward to local prosecution? What challenges do local and state officials face in investigating and prosecuting cases? And are there practices that would improve the ability of state and local police, prosecutors, and courts to move cases forward from identification and investigation to arrest and resolution? So to go through the methodology to answer these research questions, we used a multi-method approach involving both quantitative and qualitative data analysis. We selected 12 primary study counties and 3 comparison sites using a non-probability purposeful sampling design, which involved a multi-stage cluster sampling approach. We decided on this targeted approach rather than a random sample, since we know that human trafficking investigations are still rare among local agencies. So while a random sample may have been the preferred approach in many types of research designs, doing so for this type of a study when we know that local agencies are still, most reluctant in their investigations would not have turned up a rich sample. So we targeted our sample. It's important to note that because of this, our sample is not nationally representative. So the conclusions from the study cannot be generalized beyond the 12 study counties. So we can't say that based on what we've learned, this is what happens in the United States. But that being said, our study does currently represent the richest source of information about human trafficking investigation and prosecution at the state and local level. In addition to in all of the 12 counties, we conducted case reviews. In the end, there were 140 closed human trafficking investigations that we reviewed. We conducted interviews with local law enforcement, federal law enforcement, local federal prosecutors, and service providers. And we also conducted a non-trafficking review. So we reviewed incidents that were not identified originally as human trafficking to measure potential underreporting. So we selected, as a potential proxy for sex trafficking cases, we selected 50 most recent incident reports for arrests for prostitution. And as a proxy for labor trafficking, we attempted to select 50 of the most recent incident reports for extortion and alien harboring, though that was much more difficult to get at the local level. This slide just represents some further information about our sampling and site selection. So it's important to note that we began by dividing states into one of 3 main categories, representing variation in state laws as of 2007. So we looked at where state laws were in 2007 so that we could identify cases that would have been closed at the time of our study, which happened a few years after. So in 2007, we looked at states that had comprehensive human trafficking legislation, those with basic human trafficking legislation, and those without human trafficking legislation. To be categorized as comprehensive legislation, we defined it as including criminalization of trafficking plus at least 2 additional elements intended to enhance criminal justice system responses, such as mandated training, victim benefits and services, a state task force, or a research commission or report. We categorize states as basic legislation where the laws only criminalize trafficking or only included 1 additional element. We selected, to ensure regional variation, we selected counties and states throughout the United States in different regions. And it was also important that we looked at whether or not counties in these states had or did not have a federally funded human trafficking task force. Our original assumptions going into the project were that we would test for variation among counties that either had legislation or didn't, and the type of legislation, and whether they had a task force or didn't. We expected that these factors may have an impact on the type, the nature of challenges that they identified, and the extent to which they were able to identify cases and prosecution outcomes. There were a few differences, though I think on the whole, what we found in the end was that there was really very little variation in terms of the challenges encountered by local authorities, whether or not they had a federally funded task force. This just describes the legislation as of 2007. And again, our methodology, this just provides a little bit more background. Of the 140 closed cases that we reviewed, that represented 379 suspects and 190 victims. We collected data from incident reports, investigative notes, warrants, other types of evidence, victim, witness, suspect, interview transcripts, charging documents, court records, and sentencing reports. Excuse me. And we coded all of this data. And particularly, we were looking at human trafficking indicators across cases. And I can get into that a little bit more. We have some data on that. We were looking at victim participation, case outcomes, demographic information, arrest, and charging decisions across the cases that we reviewed.
Thank you, Colleen. So I think, as you'll find, Colleen will do a fabulous job of really summarizing the highlights of the study. But I just would like to really push people to pick up the study and to read it. It is a lengthy document, but it's so rich of information. And it really supports the purpose of this webinar, which is to use the information learned from this Urban Institute study to look at the work that and what AEquitas staff have learned through trainings and providing technical assistance and researching on the issue of human trafficking, both inside and outside of the U.S. And to ask the listeners to think of their individual experiences in order to take all of this information to more effectively respond to these cases. As Colleen noted earlier, because of the methodology, the conclusions are not nationally representative, but anyone doing this work will recognize common themes that they can incorporate into their own responses. Okay. Colleen?
Thank you, Jennifer. So we had 5 main areas of inquiry, and I'll, to some extent, be presenting results from each of these 5 main areas, though I won't present much on the side of federal prosecution. I'm happy to speak about that at another time, and as Jennifer mentioned, that's certainly outlined in our report in a special chapter. But I'm going to focus today mostly on the state and local findings from our study. Although federal and state laws define human trafficking to include both sex and labor trafficking offenses, what we found is that most of the cases in our sample, so 85% of the cases in our sample, had sex trafficking as the primary offense. 11% had labor trafficking as the primary offense, and 4% were categorized as both sex and labor trafficking. So those could be cases, for example, massage parlor cases sometimes are categorized as both. So I think it's important here that we don't take these findings to generate conclusions about prevalence. I think this mostly reflects the types of cases that are being investigated by local law enforcement, and there are a lot of reasons around why sex trafficking cases are prioritized in our sample. In addition to the focus on sex trafficking cases, when we would go out and speak with local law enforcement, they would often say that if they were investigating trafficking, that they'd be looking specifically for sex trafficking, and within that, domestic minor sex trafficking cases. And when we would talk further about what types of approaches they would use to do the investigations, and when we coded cases, what we found through the data was that very much local law enforcement is sort of taking a reactive approach to identifying human trafficking cases in our sample. So 39% of cases came forward through a tip, 18% through an ongoing investigation. It was very rare that the victim or the victim's family would reach out to local law enforcement to report their victimization. And I think that's probably not surprising to many of the folks that provide services to victims, that work with victims in the investigation and prosecution of cases. And I think this isn't going to change moving forward. So the fact that victims very rarely self-identify as a victim of sex trafficking or labor trafficking and come forward to report their victimization pushes us to reconsider whether the reactive approach to identifying cases of human trafficking across the country is really the right approach, and whether it may beg for some more proactive forms of investigation, and what would those techniques look like. So to analyze whether investigated trafficking cases met the legal elements necessary to prove human trafficking, we broke down the elements of the TVPA and its reauthorizations into categories and coded cases across each site. We were then able to analyze whether there were trends of certain indicators or combinations of indicators of trafficking in the investigative files, and whether they had an impact on prosecution outcomes. So on average, what we found was that investigated cases contained 5 separate indicators of human trafficking. And the most common indicators, as you can see on the slide, were the presence of a pimp trafficker, evidence of financial benefit from sex trafficking, and the sex trafficking of a minor. So the main finding is that while 69% of identified human trafficking cases in our sample went forward to prosecution, they were very rarely prosecuted using existing human trafficking laws. With respect to both state and federal charges, only 7% of cases resulted in a sex trafficking charge, 9% in a sex trafficking of a minor charge, and 2% in a labor trafficking charge. And I should mention that all labor trafficking charges happened at the federal level. So across the 12 counties in our sample, there were no state-level labor trafficking prosecutions. And there are reasons for this that we heard from prosecutors and from law enforcement. So despite new anti-trafficking laws across states, we found that state prosecutors are continuing to pursue trafficking offenders with laws that existed prior. And in many cases, these laws are for lower-level offenses. So, for example, as bared out in our data, the most common state charges for human trafficking cases were compelling or promoting prostitution. Federal prosecutors also continue to rely on Mann Act charges of, quote, transporting a person for the purpose of prostitution to prosecute sex trafficking cases of both adults and minors. We also conducted a series of bivariate analyses to determine whether certain types of cases or certain legislative or task force environments, as I mentioned earlier, had an impact on prosecution outcomes. And we found that in sites and states with comprehensive legislation, they were slightly more likely to bring state criminal charges than sites with basic or no legislation. But interestingly, with respect to the elements of human trafficking in the cases presented earlier, so that chart kind of outlining the elements of the trafficking crimes, we found that cases that resulted in an arrest or a prosecution on average had 6 indicators of trafficking versus 3 indicators in cases that did not result in an arrest or prosecution. And it's worth mentioning here that it wasn't necessary, that the 6 indicators were what you needed to prove trafficking to bring it forward and charge it that way. But it reflects perhaps, and we've seen this in other research and literature on other new crimes, that perhaps in the early days after laws are being passed, that there may be a reliance on cases that are stronger in a sense, that they have more elements, more evidence to go forward. And we heard from some prosecutors that they were sort of interpreting the laws differently, so that while you don't need to show force and fraud and coercion, in a sex trafficking of an adult case, for example, you would just need to show one of those elements, so the law states force, fraud, or coercion, that prosecutors were moving forward with cases that had all three elements. And as we know, if the victim is under the age of 18, you wouldn't have to show the force, fraud, or coercion because it's inherently considered that the child cannot consent to the trafficking. Still, prosecutors were moving forward with cases where they were showing those elements. And the reasons that we heard were that they wanted to protect cases upon potential appeal. And they thought that in some cases they might sit better with juries. So this chart just shows state and federal charges that were used for the cases. So as I mentioned earlier, you can see here across cases, so the top charge at the state level was compelling or promoting prostitution. And then if you look down, the top charges federally, you can see alien harboring. So this would be for labor trafficking cases. The top charge is alien harboring and not labor trafficking. So you can see it's very rarely used. And that also, the Mann Act is still being used quite often for adult and minor cases of sex trafficking. So this chart just shows the dispositions of suspects. So you can see that for those cases that were charged at the state level, that the majority of cases were resolved through a guilty plea. About 41% of all suspects across all types of counties with different legislation. 36%, still quite a high amount of cases, were not prosecuted. They were dropped for prosecution. And as I'll talk about later, one of the primary reasons for that we heard was victim cooperation, that investigators and prosecutors cited that victim cooperation in potential prosecution of a case was the number one challenge that they were met with. And so if they didn't, we were told if they didn't have a victim, they didn't have a witness, and they didn't have a case, and so those cases wouldn't move forward in many cases, or they'd be charged differently. So on the federal level, 67% of cases are being resolved through guilty pleas. And a much smaller amount, only 10%, are going through to trial and resulting in guilty pleas that way. And roughly 20% are dropped for prosecution on the federal side. So we conducted a series of analyses to see what factors might lead to arrest and prosecution. So we found that arrest and prosecutions were more likely when a case involved a minor victim, when a case had evidence that the suspect knowingly benefited financially from human trafficking. And that's important. There are cases that I'm sure many investigators and prosecutors out there are aware of where it's very difficult to show the financial benefit from the human trafficking for, a variety of reasons. We hear that it's difficult to access financial records, that traffickers spend the money as soon as they get it, or they rely on these green dot cards. So there is really an inability to access bank account information to demonstrate financial benefit from trafficking, though I think Jennifer will speak about later that there are techniques that can be used, and so it's a matter of educating investigators and prosecutors as to how to sort of work with these challenges to show this. Also, arrest and prosecution were more likely when suspects, they were more likely to be prosecuted and convicted in cases where there was collaboration among local law enforcement agencies. So this does speak to the task force model. So the task force model seems to lead to, when you have collaboration, it's more likely that a suspect will be prosecuted and convicted. So collaboration in these cases is key. Labor trafficking cases were different. So suspects were actually less likely to be arrested in labor trafficking cases than they were for sex trafficking cases. And suspects were less likely to be found guilty in labor trafficking cases than either sex trafficking suspects or suspects in cases of both sex and labor trafficking. And we're actually, Urban Institute Northeastern are currently conducting a study funded by NIJ looking specifically at labor trafficking in the United States right now. The study should be finished and wrapped up by early next year. So we're hoping to learn more about the specific difficulties with prosecuting and investigating labor trafficking cases and providing services to victims. In terms of identification challenges, these are sort of findings from our interviews with state and local and federal law enforcement, prosecutors, and service providers. So we found that it's a low priority for law enforcement, that if they were investigating cases, that they were looking for domestic minor sex trafficking cases. That was the priority. And, we heard in one jurisdiction, for example, that when we asked, why is it a low priority, and asked about resources, the chief of police in that jurisdiction said that 99.9% of all potential victims of trafficking, sex trafficking, are crack whores. And this is why they decided not to dedicate resources at the local level to investigating these cases. And this speaks to the negative attitudes that we heard across sites towards victims of these cases, which was a big challenge that we heard. That in some cases they're seen as deserving of their victimization. And so this confronts, while we may have laws in terms of the policies and the procedures on the ground, the negative attitudes really provide a barrier to that. And coupled with that is a lack of training and awareness for first responders that we heard, a reactive approach that law enforcement is just waiting for tips, and we know that the nature of the crime is hidden. And so having a reactive approach is not going to uncover the cases that are out there. Specifically when those that are surrounding both sex and labor trafficking victims are unlikely reporters, so they're benefiting in some way from their trafficking and therefore would not be likely to come forward to report their victimization. And again, as I mentioned earlier, many of the victims will deny their victimization, or they don't see themselves as a victim of this type of a crime. They may see themselves as a victim of an assault, or that they're not being paid, but they are often unaware that these laws exist to protect them and therefore would not come forward. The fact that I think there is a challenge inherent in human trafficking in that the behavior of the victims of trafficking, both sex and labor trafficking, is often criminalized, and therefore it presents an extra barrier for victims to come forward. So if a victim is involved in commercialized sex, then they would be reluctant to come forward to report their victimization because they may be afraid that they'd be arrested and charged with prostitution. And also, in terms of both labor and sex trafficking victims, for those that are in the United States that aren't documented, they would fear coming forward because they would fear deportation. And unfortunately, as we found in our study, and often these are threats that traffickers will use to control victims to prevent them from coming forward. And as we found in our study, the sad finding is that oftentimes this happens, so that while traffickers will try to control victims by telling them not to report because they will be arrested or deported, in fact, 35% of all victims in our study were arrested by local law enforcement. And this reflects a lack of understanding about trafficking, a lack of training to identify it and to distinguish it, and some of the negative attitudes that they might see these victims as criminals. And we also heard that in some cities it was just, quote, easier to deport the victims and get them on their way because they lack the local resources to work with them while they are protected federally under the TVPA and should be granted services and rights similar to refugees in the United States. The sort of scope of proactive investigation is also limited by the organizational structure within local law enforcement. So it was the case that the primary units in charge of doing investigations for all types of human trafficking were located within vice units, and so they're more accustomed, so they've been in the business of doing investigations into gambling and making arrests for prostitution. And so it presents, again, an extra barrier in terms of changing the mindset from looking at somebody as someone that they would be arresting for prostitution and screening for potential human trafficking. And again, there's a question about whether they might be the most appropriate unit to be conducting labor trafficking investigations. So across all study sites, we found that there were no special units to do labor trafficking investigations. Sort of, if a case came forward and was reported, they might work that case, though I think it presents another barrier to local law enforcement because they have not been in the business of conducting any similar types of investigations into, for example, wage and hour disputes. Those are commonly handled by Department of Labor. So there's even a sort of a more of a lack of awareness and training and knowledge from local law enforcement in terms of how to handle labor cases, potential labor trafficking cases. And so that's something that I think is reflective in the numbers. It shouldn't be a surprise that perhaps 85% of cases that were handled were sex trafficking cases. These are just some quick quotes that we heard from our study, and the report is very rich in outlining a lot of quotes that we heard from stakeholders. So reflecting the reactive approach, we're simply taking cases that roll into our lap, or a beat officer will roll up on a car where a 15-year-old is having sex with a 40-year-old guy, and we start an investigation and just continue to mushroom from there. That's how we get our cases down here. You may have labor trafficking going on, but we're missing it. Most of the trafficking we see is little girls that are runaways that are getting exploited by some schmo, and we run into that. Our vice unit will expose a lot more of that. So that was from a site that had basic legislation, no task force. It was in the Midwest.
Thank you, Colleen. And so I think when you hear all of the barriers to identification and just the findings from the study, it can be so easy to be discouraged. But I think the silver lining here is that the solutions for overcoming the barriers and identification is what we're focusing on now, but it really follows through to all of the other areas as well. The solutions are really well within all of our grasp. There is nothing inherently complicated or complex about it. It's just a matter of understanding and getting the training on the laws, having training and removing the bias and the stigma that prevents the folks within the criminal justice system and the community from seeing these victims and the perpetrators, and really collaborating and getting training from peers who are working on sexual violence, domestic violence, child abuse, very different crimes, but with very similar dynamics. So the techniques and the dynamics in those crimes, understanding them can be very beneficial to approaching human trafficking. Similarly, speaking with our financial crimes folks and the gang unit, there's a wealth of information within the system, and if we sit and talk to each other, the solutions are really within our grasp. We just haven't made ourselves aware of them. And one of the biggest approaches that is in the violence against women, domestic violence, sexual violence world is this victim-centered, offender-focused approach. And what it is it really is the philosophy by which prosecutors and investigators approach these cases to, in essence, get out of their own way so that they start seeing the evidence that's in front of them. And what this basically means is a victim-centered approach to a prosecution or investigation is based on an awareness of the central role that victims or survivors play in the criminal justice system, and a consideration of their safety, privacy, and well-being throughout the process. It also includes the understanding of the impact of participating in a prosecution of the victim, how that impacts the victim, and ensuring that this victim has access to services, support, and information. And how this translates is really into the prosecutors and law enforcement really seeing themselves as important pieces of a very important collaboration and cooperation against this crime. The offender-focused approach is really it's born out of the acknowledgement that offenders purposefully, knowingly, and intentionally target victims who they believe they can successfully assault. So, for example, they take advantage of vulnerabilities. They know that their victims may be engaging in collateral criminal conduct, things that will prevent victims from coming forward to report their victimization or from being seen when they do come forward. It really keeps the focus on the actions, behaviors, and characteristics and intent of the offender. And I can't stress how important it is in the approach to these crimes. Another thing to really keep in mind when we're talking about the solutions is that very few, if any, of these solutions need to be created from scratch. There are examples all over the country, in fact, all over the world, of innovation, of prosecution and investigative practices, of trainings, of services and support and advocacy for the victims. And the real innovation, because we so often see groups or jurisdictions having many things going on that may not be coordinated, the real innovation is in coordinating what's in your jurisdiction, but also finding out what others are doing and taking that information, refining it, or adapting it if necessary, and then implementing it in your own jurisdictions. The roles of prosecutor and law enforcement cannot be overstated. Prosecutors and law enforcement have a particular duty to lead and to support efforts, and their important role in educating allied professionals and the public about human trafficking and related sexual and physical violence cannot be overstated. And one of the most important quotes that I think came out of this study that really spoke to me was the difference between law in the books and law in action, which really showed how the importance of not only the policy work but the implementation. And so for prosecutors specifically, where are we fitting into this? You know, it's all in our ethical yet aggressive approach to cases, knowledge-based, that we're looking at cases not through the lens of bias and stigma, but through real information, through understanding the dynamics. We're making decisions on going forward with cases that's based on competent knowledge of the law and all of the relevant tools, evidence, and other investigative tools that are available to us, that we don't approach cases with a fear of losing, but rather we go forward on those cases where we know that a crime has been committed, we know the identity of the perpetrator, and we know that these crimes should be going forward. And when we look at our role, it's beyond just a specific case. It's really in terms of implementing different practices in the criminal justice system that can keep victims safer. And we focus again because our organization works with all criminal justice professionals, but because we're focused on the prosecutor, we really want to focus on the specific duty of the prosecutor, because everything we do is really grounded in the ethical obligations and the justice obligations. And this work, this collaboration, this approach to these cases has its grounding in the prosecutor's most basic duty of achieving justice. And we've included a very old Supreme Court case, but it really does describe the prosecutor's duty in the criminal case as being as much about refraining from improper methods as it is about bringing every legitimate means to bring about a just conclusion. And so, again, keeping that in mind, it's really about our duty to fill in this gap, overcome these barriers that have been so carefully identified for us by the Urban Institute. A key piece in terms of overcoming the barriers is and a key component to successful, or I guess where there were unsuccessful cases, this report noted a lack of coordination among all the different parties. And again, just cannot stress the importance of collaborating and the importance of prosecutors understanding that the prosecution of a case, the criminal component, is not by itself going to put an end to human trafficking or going to keep a victim safe. It is a critical piece it must be effective. If it ignores or overlooks victims, victims cannot be safe. But it's also a piece of a larger puzzle. So while prosecutors don't have the knowledge or the skills to be able to help with economic or civil issues, and may not be competent to do all of the training in the community, they have to understand how important that is for them to do their work, for us to do our work. When I talked about the silver lining in terms of one of the things that can make such a difference is training. And there is so many areas where there's incredible training going on, but there's still so many areas that are lacking. So I think the first lesson that we've learned is not only from the study, but even from our own work, is not to take for granted, even if you're in a jurisdiction where there is a great response in one area, not to take for granted that everyone within the community is aware of all of the pieces. There are so many individuals in the system, and one of the biggest challenges is that victims of these crimes intersect the system at so many different places, and while there are so many opportunities to be able to identify the victim here, if you don't have child welfare, for example, up to speed, if you don't have welfare individuals up to speed, if you don't have, your health and safety, your licensing agencies, corrections, if you don't have everyone trained on the elements of human trafficking and on the dynamics of these cases, the victims are going to be missed, and that missed opportunity just doesn't need to happen anymore with all of the information that we know and all of the different ways in which our communities are coordinating over separate efforts. It's time to stop operating in the silos and really come together to find out how we can use other collaborations to enhance the response to human trafficking. Again, not taking anything for granted, making sure that people understand the elements of human trafficking, and certainly individuals, prosecutors, and law enforcement need to consult their own specific state laws as well as the federal law. But the basic elements of it are the same, and really while there could definitely be better refinement of some of the current laws, prosecutors really do have the tools they need to go after these cases, and it's just a matter of being critical in how we go forward on these cases and being very methodical in partnering with correct agencies and individuals to identify the right evidence, to identify the right laws and rules that will let us go forward on these cases. As I talked about in the beginning, one of the key components that we have found from our experience is that understanding or acknowledging the high rate of co-occurring violence in these human trafficking cases, and that co-occurring sexual violence, the incidence of rape, intimate partners who are trafficking others, family members who are trafficking children, the components of stalking and other abuse. These are all, first of all, within the study, there was a high rate of co-occurrence of these crimes found. Excuse me, I'm sorry, didn't mean to go forward. There was a high rate of co-occurrence found in the study. But similarly, if we understand how interlinked human trafficking is with these other crimes, it gives us another tool to better identify victims. Again, not only because we know victims can intersect the system or individuals at very many places, it gives us other eyes to be able to be aware of the indicators and to start becoming aware if there's a human trafficking victim that they are coming into contact with, so that they can then connect with the law enforcement and other advocates to be able to help them. But training on this is important. And I think that some of the statistics about victims, particularly in sex trafficking, being marginalized because they're dismissed as drug addicts or people in prostitution, the arrest rate, a lot of this is really, truly a result of just not fully understanding the pathways into prostitution and the violence that's directed at individuals in prostitution and the dynamics in sexual violence and DV that really do play a role in understanding some of the human trafficking cases and may get some individuals, particularly vice and other officers who aren't particularly trained in human trafficking. It provides the thread to be able to bring all of these cases together. And as I said earlier, too, the strategies that have been used by sexual violence, child abuse, and DV prosecutors and investigators and advocates can be very helpful in these cases. In terms of other areas of training, too, the cases are routinely missed because individuals either believe that the victim has to be foreign, they don't believe that trafficking could be happening within their jurisdictions, within their neighborhoods, on lawful, and I say that in quotes, perceived lawful sites, construction sites, and it's just a matter of really taking a broad brush and educating the community as to the different points. And again, just with all of these different identification points, it can feel overwhelming, but really what it is the opportunity to be able to identify victims. And, there's no one person who's responsible for all of this. If everyone is trained, victims will stop slipping through the identification gaps that have been notified. Colleen?
Thank you, Jennifer. So I'd like to just briefly go over some of the investigation challenges that were noted by local law enforcement through our interviews. So one of the themes we heard was a lack of victim cooperation, both from investigators as well as prosecutors, but yet this dependence on victims. So as I had mentioned earlier, often we would hear things like, if I don't have a victim, I don't have a witness, I don't have a case. And because victims are confronted with a variety of challenges that impede their cooperation, it was perceived by the stakeholders that we spoke with that they were not likely to cooperate in cases. But I should mention that this was often hampered by the fact that many of the jurisdictions in our study really lacked any sort of specialized services to support victims throughout the case. And so this may be then viewed as a lack of victim cooperation or them being difficult. But if we don't have the services in place that are specialized to support them, we should expect that there will be difficulty keeping them throughout the case. In some of the counties that we visited, because there was such a lack of services, they had to, in some cases, send victims, in many cases minors, out of state to receive services from a specialized service provider since they didn't have any in their state. And this also, while they were receiving services, still presented barriers in terms of prosecution and getting them back to the state to testify in court, to meet with them. So all of those factors are at play. We also found and heard that, police are really unprepared for the degree of victim trauma, so that, the symptoms of trauma that would come out, and were encountered by local law enforcement, for example, in the form of a victim perhaps recanting, or, we would hear often investigators would say we'd have to interview her 5 times and her story would change. And some investigators that were trained understood the reasons why the story might change and wouldn't hold it against the victim, but in other cases, investigators would view that as the victim lying and didn't really know how to handle that, and so might not go forward with that case because of it. And so if they were very much lacking in terms of their training on how to work with the victims in these cases that have suffered so much trauma. We found that in human trafficking cases specifically that victims often require services for a longer period of time, perhaps, than in other types of cases. And this was something that was new to local law enforcement and was, specifically when they lacked local services that were specialized, it was difficult, and they would often go to great lengths to cobble together services that they could find, but sometimes it just wasn't enough. And again, going back to some of the trauma that police would encounter with victims sort of recanting, we would find that they would tell us they would use tactics that are normally reserved for suspects. So they would arrest victims as a means to detain them, to secure their cooperation. We heard there are quotes in our report. For example, local law enforcement would say they would have to, quote, break the victim, or they viewed arresting the victim, and this includes minors, as a method of detox from the trafficker. And sometimes, police would arrest because they viewed the victims as criminals. Sometimes they would arrest as a means to sort of get their cooperation. And sometimes they would do it, and they would tell us that we know it's not right, but we really don't have anywhere else to put her. We don't have any shelters that are secure. We're worried about her safety. We know she's going to run away, so we feel limited, and this is the option that we feel we have, which is to arrest. Though, I shouldn't have to say this, obviously, for everyone here, but the repercussions of using arrest to detain victims in these cases, any cases, is severe. And so that also feeds into why many of these cases wouldn't go forward under trafficking charges, because you're arresting a victim, even if you have the best intentions in your mind behind that, that will affect their ability and willingness to cooperate, and them seeing themselves as a victim deserving of resources and protection under law. Often we heard that the credibility of victims is challenged by supervisors or prosecutors. So law enforcement would tell us that, they do an investigation, take a case forward to prosecution, only to have the prosecutor come back and say, we need more victims. I'm not going to take this case if there's only one victim, because it's sort of a he said, she said. We need more corroborating evidence. This goes back to training from local law enforcement, but also collaborating between law enforcement and prosecutors around what type of evidence is necessary under state laws to bring forward, so that you don't result in this negative feedback loop. So what we found in many cases was that, law enforcement would bring cases forward. They would get resistance from state or federal prosecutors to take a case, and it could have been that it only had one victim or one suspect. From the federal level, we heard in many state sites that they preferred multi-victim, multi-suspect cases, and also would only be looking at domestic minor sex trafficking and not adult sex trafficking cases. Similar things happened on the state level. And so this all comes back to local law enforcement, where if they feel that, adult sex trafficking cases are not going to get picked up for prosecution, or single victim cases, even in labor trafficking, are not going to get picked up for prosecution, they lose their own institutional resources and support to continue those types of investigations. And so they may then only do types of investigations into crimes that they think will result in prosecution. So that's something that, and it also happened the other way, where they had willing prosecutors that were interested in taking cases and would take that risk to charge, a new law. Then they were more encouraged to do those investigations and bring more cases forward in the future.
Thank you, Colleen. And so in talking about improving the investigative techniques, one thing we want to just do is remind listeners to go back and think about the training, because this plays a big piece. And, one great example is one of the points that Colleen just ended with about this minimization or ignoring of adult sex trafficking in favor of domestic minor sex trafficking. And what I always find interesting about that is that if we know the statistics of the average age of entry, and some jurisdictions will say the average victims that they've picked up are 15 years old, and that the life expectancy is 7 to 9 years. I mean, it takes very simple math to realize that domestic minor girl who will will likely not be identified is going to end up being an adult trafficked victim until he or she is killed, likely in the line of work, or dies from a drug overdose, or somehow is harmed. So this is where the training into the pathways about the crime into the realities and the violence perpetrated against prostituted individuals, whether or not they're ever identified as trafficking, really makes a difference, and linking the two responses is very key. But again, the points we made in trafficking are in the training portion on this, and also the elements of the crime which really required are relevant here in the investigative section. And another example where, really working with some of the other prosecutors, for example, sexual violence prosecutors, and, the attrition rate, the rate at which cases are not taken, sexual violence cases, is also very high. But experienced sexual violence prosecutors know that if you are not losing your cases, that means you're not taking the hard cases. And the same is true for human trafficking. And sexual violence investigators and prosecutors are very skilled at recognizing that oftentimes there are no witnesses to these crimes, traditional witnesses, but we can find other corroborating evidence, things that will corroborate the victim's testimony so that you can go forward with a single victim. Because just like in sexual violence, just like human trafficking offenders, sexual violence perpetrators, what the research tells us is that they have a lot of victims. But it is far and few between where we're going forward on a case against a single perpetrator in the sexual violence world and multiple victims. So oftentimes it does come down to the testimony of a single victim. And this is where really collaborating with the special victims, child abuse, and adult sexual violence investigators and prosecutors can help improve the investigative techniques and find that corroborating evidence. And then the coordination, again, that we talked about above in identification is also very critical to investigations. We wanted to highlight a BJA map showing the 42 human trafficking task forces, and then there are 12 comprehensive task forces. And the key, again, is to remember that even if you're operating in a jurisdiction with these task forces, you still really need to review, incorporate, and adapt existing initiatives that might be going on in human trafficking that might not be pulled into this task force. And also domestic violence, sexual violence. The concept of a coordinated community response is what we do in domestic violence. Sexual assault response teams, the SARTs, this collaboration, and sexual violence teams, child advocacy centers, and there's collaboration in child sexual abuse and child abuse cases. It's really a matter of making sure that everybody's at the table and everything is connected, that people are sharing information not only on cases but on tactics, because we always learn from talking to other people. We'll learn about emerging tactics, we'll learn about issues, and we may find that a victim we're working with on one issue is being victimized in other ways. The key is also to understand that, and I made this point earlier, that we don't want to assume that everyone is working together, even in the most experienced jurisdictions. The best mark, I think, of an advanced jurisdiction, a jurisdiction with an advanced effort on human trafficking, is that they constantly ask themselves who's missing. And some examples of partners who are commonly overlooked are labor, and of course, talking about the huge number of labor trafficking cases that are overlooked. There wasn't one state prosecution. Having labor at the table is very important. Or your EEOC representative. Corrections. The corrections to help with trafficking going outside and inside institutions. State tax investigators and licensing agencies, people who look at health, safety, liquor, other licensure or tax returns. These are individuals who can help flag if, perhaps someone's filing a false return or not filing at all. It may give you an opening to get into business or to get into the finances of a person, an individual who's engaged in trafficking. As was mentioned, and we'll talk a little bit further into this section on the importance of doing these evidence-based investigations, those investigations that don't rely totally on the victim. But the victims do play a key component, and even where they're not playing a key component, keeping them safe is, paramount in order to get them out of that situation. So I cannot underscore enough the importance of housing. And we all know with current resources, there is simply not enough housing for all of the victims of human trafficking. However, there are communities and jurisdictions, as we'll talk about a little bit later, that are really using the tools that they have or being very creative in getting housing for the victims. Another thing to think about is not only who's on the task force, but the different roles and responsibilities. And just to highlight that everybody on the task force has a different responsibility. Law enforcement and prosecution don't represent the victims. They represent the community, the jurisdiction where they are. They have different missions. And so it's important having advocates or having civil attorneys or some sort of representation for the victim as well. And just recognizing that there are going to be issues with confidentiality, with privilege, different things will come up, and it's always so important when we're setting up these coordinating groups that we try and address these issues beforehand with protocols and policies before we have actual cases coming in front of us. Another point that Colleen made was this difficulty that some law enforcement and prosecutors may have in working with victims of trauma. And as is obviously from individuals who have worked on these cases, that there is incredible amount of trauma. Not only do you have the human trafficking, but you are victims of sexual violence, of physical violence, and so I think there needs to be the recognition of the role that trauma plays in a victim's response, not only to the incident as it's happening, but through her response to questions and response to the criminal justice process, and also the understanding and training on how to deal with it. And the first place this comes in is in terms of being proactive, in terms of understanding that the individuals who come through the door are not, cannot be discarded because of their place in society, because they might be involved in other crimes. I mean, it's just not what we're about. As a prosecutor, in my jurisdiction, we're always told there aren't two courthouses, one for, the perfect victims and one for everybody else. And so it's just a matter of, again, informing those people who are going to be able to really intersect with the victims, the people that have been targeted by the human traffickers, and try and get to that identification point before you have a victim coming in and being arrested for that collateral crime. And there's many ways to do this in terms of, and this goes back to not making this totally dependent on the victims. Doing these very concentrated, methodical investigations. For example, when you're looking at ads, are you taking, understanding that not everyone works the same way, but, for example, do you have a free weekly? If so, can you look at the back pages about escort ads and maybe analyze them over a few weeks? Do you see that there are numbers that are staying the same, but maybe the description of the individuals are changing or the address is changing? Are you seeing some sort of commonality there? Are you able to, sit on a site and do some surveillance? And are you observing? Are you observing workers leaving or not? Are you observing clients going in? Again, there's no one particular way that every place is going to operate. These are organized, but they are disorganized organizations. But, it doesn't take high-tech, expensive surveillance to just be thoughtful about what we're looking at and to come up with a method so that when we're surveilling it, we can better identify the indicators that are right in front of us. And then there are some other proactive techniques that are there. In terms of the suspected premises, not only the rates, but this is, again, where proactive policing really can talk to the licensing folks who are colleagues who are in these establishments again, checking for a liquor license or for safety violations to make sure that they are trained on the indicators of human trafficking and that they know to call the police so that then the police can do their job and set up surveillance and really provide the protection. And just, again, this recognition of the high rate of violence and exploitation and threats just makes it so important for us to understand the incredible trauma that these victims are have endured, so that when we are, intersecting with them, when we're identifying them, when we're taking them, we make sure that there's medical attention, we make sure that there's advocates, we make sure that we're providing an environment that is responsive to the fact that they have gone through this huge amount of trauma. And some of the best work on trauma that's been done is by David Lisak. And so, and when he talks about this trauma, again, this is something that I think we all know common sense-wise, but when we're stepping back and looking at victims of these crimes, oftentimes we have expectations of how a victim should act, and we don't often just think about the realities. Beyond our own common sense, there's actually been work done. And again, no victim is going to act identically, but what we do know is that there can be gaps in memory. It can be fragmented. So, and you certainly, when you're a victim coming out of trauma, you're not going to remember, you may not be in a place where you want to talk about everything that's happened to you. Disclosure is a process. And again, this is something that we see in the related crimes of sexual violence and intimate partner violence and child abuse, which are often going on at the same time as human trafficking. And so it's important to understand that. It's important to know that it's not uncommon to find inconsistencies or gaps in the information. It's not, uncommon to have a victim who doesn't want to report, who may want to maintain contact with the offender. They may be in intimate relationships with the offender. It could be, again, a family member. There could be intimidation being used, and we know that this is very common in these cases. And again, we have to understand that identifying these individuals as human trafficking victims is, certainly a goal, but not overlooking the other violence that they have suffered and responding to it. And we may not get within the course of an investigation, we may not identify that someone has been a human trafficking victim, but we might identify that they're a victim of rape or attempted murder or some other violent crime, and it's important to have a process that responds to that, both a criminal justice process and an advocacy and medical response. And we do have great models in the sexual violence and intimate partner violence world in terms of responding to this. I think the most important piece is that prosecutors and law enforcement who understand that victims are individuals, that they have varied responses to trauma, and that we don't look at these at the victims' responses as indicators of their lack of credibility, but otherwise as real responses to what they've gone through. It again helps be more knowledgeable about the approach to the case. We don't stop, we don't automatically think that someone isn't a victim, particularly because individuals who are in sex trafficking or other labor trafficking may have undergone horrific violence and may minimize the reports. They may not seem to be very upset about the violence, and it's just important not to take that and draw conclusions about the whole case. The other piece that that we talked about earlier, and it is relevant here in terms of the investigation, if the victim's other issues, if their health and safety are not taken care of, if they're not going through sexual trauma counseling, if they don't have a safe place to live, if they don't have food, very difficult to participate in an investigation. I mean, literally, you may not be there, you may not be able to participate. And we'll talk about arrest of victims later, and I think it's a sad commentary that in some jurisdictions they believe that this is the safest alternative they have for victims. But beyond the obvious stigma and fear and division that happens between law enforcement and a victim when you arrest them, jail is not a safe place for a victim. There's human trafficking that goes on in there. When you speak with survivors who've been trafficked or under pimp control, when you are pulled off the street, there is an obligation to be making money. And so you are expected to be recruiting in prison, or you may be open to being recruited. So it's not a safe alternative. So really looking at these basic needs are not luxuries. They're very important for the going forward for the benefit and the success of these cases. The other piece is really understanding, a person who's forced into prostitution, even if you have a victim, again, who's not identified as a traffic victim, but you have identified and made out a rape victim and you have a perpetrator, charging this individual with prostitution is not in the best interest of justice. And it's really, these are the decisions we have to think about as prosecutors, and we make them every day in terms of how we go forward. This piece of not relying on the victim to put a case together, again, cannot be overstated. And we talked about lots of this earlier. Other areas, again, in terms of discovering and tracing financial information, this is where working with financial crimes experts is very, very integral. Looking for any suspicious activity, the Department of Treasury can help investigate and analyze, financial inconsistencies. We understand and we're hearing that they're not finding that places aren't finding a lot of cash, but these green cards, these reloadable cards are being found. They may be hidden, and it's important when conducting search warrants and when questioning that we're getting the right evidence to be able to discover these things. Be aware that there may not be obvious records or assets, but you can look at not only financial crimes, but your narcotic folks, your gang and other organized crime, white collar. They can really help untangle complex or seemingly absent assets. And I think the other thing I would just, like to point out is just, when we're in finances, let's not confine ourselves to this magic $10,000. Human trafficking victims can be savvy, even remembering, that deposits may be put in at smaller marks so as not to trigger that $10,000. So, maybe just broadening our request to ask for other large deposits. And in terms of monitoring jail calls, looking for evidence of intimidation, recruitment, looking to see whether there are any attempts to contact the victim. And reading all communications from jail, Facebook and other internet access should be limited, but that doesn't necessarily mean that it is. People conduct high-level businesses from inside jail, so it's just understanding where to look and to really read all communications, and also understanding that as technologically savvy as our criminals are, they also know that as investigators and prosecutors, we're becoming savvy as well. And so there's a movement in some places and sometimes to stay off technology altogether. So we really have to merge our most high-level understanding of technology with our most basic law enforcement and prosecution skills so that nothing is overlooked. And just more evidence-based techniques that are in the handouts that you've been given and that are across the screen. And in terms of thinking that too, never forgetting that interviewing the defendant, never miss the opportunity to interview a defendant. They may not talk to you, but defendants may talk, and there may be a wealth of information. And for law enforcement who might be, coming across someone while on routine patrol, always remembering to write down whatever the offender says. They're saying something. Don't make a judgment that, well, they weren't Mirandized at this point, or I don't know if that's important. Write down everything that they say, because as prosecutors, we're going to be combing through it, and we may find something in there that becomes that we have context for through other investigation, and it may become relevant. And again, this need to respond to all victims, regardless of whether they're identified as trafficking victims, is very important. We have a lot of information on witness intimidation, and again, the prevalence with which witness intimidation happens it's a constant. It's sometimes said to be the most, it's most successful because it's rarely reported. We know that victims of DV are routinely threatened and manipulated to drop charges, and victims of human trafficking are intimidated or cooperating witnesses in these cases. They're vulnerable to threats not only by the trafficker, by the trafficker's associates, if you've got organized crime or gang-related violence involved, but also understanding the complex layers of individuals, other trafficked individuals, that these are neighborhoods, that these are there's a network in terms of, if you have an individual from another country, the intimidation can reach all the way back. So it is very pervasive, and it can seem very overwhelming. However, it is manageable. It's manageable when we know what to recognize and we're looking for it, when we understand its prevalence, when we know that the tactics used are subtle and we, again, are aware of them so that we can pick them up in our jail calls and we can prepare our victims for picking them up, and that we understand how to detect them and document them and then respond to them. Witness intimidation can and often does result in the failure to report crimes. It can result in the refusal to speak with investigators, in the recantation of statements previously given, a refusal to testify at trial, or you'll have victims who will testify in favor of a defendant who may actively oppose a prosecutor's case. You may have some claiming the Fifth Amendment. And the traditional responses to all of this was, vigorous prosecution, witness relocation program, intensive monitoring of offenders, and enhanced courtroom safety. But there's also more, again, less costly things that we can do as individuals to, even if we're inquiring into the acts, again, these subtle tactics that we can determine our intimidation. And even if they don't make out a crime, we can use them in connection with other rules of evidence to admit some evidence and testimony and statements from witnesses that might not otherwise have been admissible. And so witness intimidation is a topic that we literally can talk about for several days. And so I just wanted to push folks to our initiative that AEquitas is working on with pilot sites, and we are producing resources, including written materials and a model to track and identify intimidation in your jurisdictions. And so I would just ask folks to contact us for additional information on that. Colleen?
Thank you, Jennifer. So just quickly to go over some of the challenges that we heard from state and local prosecutors, barriers that confronted prosecuting cases using existing human trafficking laws. So we heard that prosecutors were reluctant to use new laws for many reasons. So one was that some were just not aware that they had state laws. In fact, one of the successfully prosecuted cases, the first case using a state law in our study in one jurisdiction, was prosecuted when there was a changeover in leadership and a prosecutor received a stack of cases that she was given and saw that one of the cases was charged with pandering and thought to herself that there must be something more severe that it could be charged with to really capture the severity of the offenses that she saw in the record. And so she really just started going through the statute and found the human trafficking law that way and charged it and was successful. So we shouldn't take for granted that prosecutors everywhere are aware that trafficking laws exist and that they are also, even if they are aware they exist, that they're aware of the specific elements necessary to bring the case forward under those laws. This is, there's also just a lack of precedent. Because these laws are so new, there's a lack of precedent in case law, and so those factors may inhibit a prosecutor from being willing to take a case when they do lack precedent. So prosecutors would say they didn't have jury instructions, they had to create them on their own, there was nobody that they could talk to get advice about how to use their state trafficking law. And so all those factors might impede going forward. As I mentioned earlier, no state prosecutor had prosecuted a labor trafficking case. Even in counties that had, where there were prosecutors that really did want to use the law or felt that it was important, sometimes they would run up against a lack of support from their agency to use the laws. And so that, their supervisors would say, this is just an awareness-raising statute, just use the laws that are already on the books that you're comfortable with and then take it that way. There was also a lack of institutional infrastructure, particularly both with sex and labor trafficking, but particularly around labor trafficking. We would speak with prosecutors that had handled sex trafficking cases, and it would ask what would happen if a labor trafficking case was referred to your agency, who would handle it, where would it go, and they often didn't know. They said, well, it might be me, but I'm not really sure. We really don't know where those cases would go. And in some cases, they would say that there were these jurisdictional issues. So specifically with labor trafficking cases, we would hear, well, you know, because those cases might often involve immigration issues, that the victims might be undocumented or have other issues with immigration, that it just sits better on the federal level. There was also just a lack of training across sites in how to use these laws, how to investigate and litigate cases using state laws. If prosecutors and investigators had been to trainings, they were most often Department of Justice, federal trainings, which are great in terms of, you know, raising awareness about the law and providing examples of successfully prosecuted cases on the federal level, but really are not going far enough in terms of giving very specific state-level information to prosecutors, to law enforcement, about how to actually put their state laws into action. And again, we heard often that there was this view of victims as bad witnesses because they were uncooperative, because they might have past criminal behavior or collateral criminal offenses that happened. And I think it just goes back to what Jennifer had mentioned earlier about, you know, not having two courthouses for good victims and bad victims. And so, you know, it also speaks to looking at services and getting supports necessary to mitigate some of the challenges around working with victims in these cases. And I will just briefly go through some of the quotes just in the interest of time. This quote is about, you know, they're high-profile cases. The last thing you want to do, a prosecutor wants to do, is stick your neck out and wind up getting an egg on your face because you failed in your prosecution, and nobody wants to fail on a grand scale, which these cases turn out to be. And this reflects an experience where a prosecutor did go forward with the trafficking law and lost the case because the defense attorney had argued that human trafficking only involved bringing victims across state lines from another country, and therefore, because it was a domestic minor case, it wasn't trafficking, which we all know isn't true, but it was believed this influenced the jury. This sort of gets to what I mentioned earlier, lack of agency support. So why bother with this goofy human trafficking statute? Just charge other crimes you're more comfortable with and you've used in the past. And, you know, that some people look at the statute as a publicity thing, like, oh, there's a human trafficking statute. Do we really use it? It's just an awareness-raising statute. So this is from a prosecutor that actually was determined to bring cases forward and charge them, but was encountering a lot of resistance from her supervisor. Jurisdictional issues, this talks about that labor trafficking cases, that in many jurisdictions they think they sit better with the federal government. However, it's not the case that all cases referred federally for labor trafficking would be prosecuted. And then if there's no state prosecution of that case, they may just fall through the cracks. So just a few other challenges. As was mentioned, the lack of resources, particularly housing that is secure and specialized. And this results in a lack of cooperation, and in some cases, we heard, unfortunately, that unauthorized victims of trafficking were being deported when they lacked resources to support them, even though they are protected under federal law and some state laws. So there was this use of other laws that we saw, and it was interesting. In some cases, a prosecutor that had used the state human trafficking law decided, because that case was being appealed at the time, that he would go forward and use strengthened prostitution laws. So in some states, they've gone forward through advocacy efforts, which are great, to strengthen laws on the books that aren't trafficking but could be used to prosecute trafficking cases. And I'm not making a judgment about whether this is good or bad, but it's just something to look at when we're trying to figure out how many cases of trafficking have been prosecuted. In some jurisdictions, we're finding that prosecutors are more willing to go forward with strengthened laws around prostitution or pandering for sex trafficking cases than human trafficking. So it's just something to keep in mind. Again, this reluctance to testify or to cooperate in cases, a preference for multiple victim and suspect cases, and challenges around judge and jury perceptions of, really trying to educate judges and juries about what human trafficking is. And I will actually just go to that, to those two slides on judge and juries, because I think they're really important. This, unfortunately, is just one of many examples that we heard about really a lack of judge awareness, that there really is a lack of training of judges around human trafficking and how that can have an impact on cases. So this is an example of a judge that was just letting everything come in about the victim's past, and it goes back to the negative attitude. So it said, at one point, because we'd asked for a lot of stuff to be kept out related to the minor victim's past, we did our standard motion of limiting, and this stuff isn't relevant. We shouldn't be allowed to talk about it. And this refers to this minor's past involvement or arrest for on prostitution charges. So anyway, so just after the girl testified, the judge said, well, I don't care about the rulings I made before. Anything is coming in because I think your girl is a lying little you-know-what. And I said, okay, well, that's where we are. So these are real barriers that confront this prosecutor and may influence whether or not cases will move forward again under trafficking laws. And this goes to jury perception. So you have to get over this, jury perception that, well, this is slavery. They have an iron ball attached to their leg, and they're wearing rags and sleeping in a shipping container. All right, real perception issues that you have to battle on human trafficking. It's hard, and the facts that fit the circumstances don't come along all the time. So as Jennifer had mentioned earlier, what to do with cases that don't come forward where the trafficking involves literally holding someone in chains or tying them up. So how to handle issues with psychological coercion, how to understand those factors, how to bring those forward and present them in court so that a jury can understand other mechanisms of control is really important.
Okay, great. So I think, again, the thing to just remember is that these cases are the toughest to prosecute and go forward on, and that if we're only looking at conviction rates, it's like fear is going to beget more fear, and we're never going to get convictions on this. I mean, people have to go forward on these cases, and we can talk about some strategies to make them successful in terms of doing it. And so in terms of looking first at assessing the case, obviously we want to look at the human trafficking charges, but we also want to look at other relevant crimes. There may have been rape, other aggravated assaults, and there's nothing to stop prosecutors from charging everything. And we're not asking people to overcharge, but you want to charge the crimes that are relevant to the case. It's important for many reasons. First of all, it can help you get in other evidence, which there are rules of evidence that can allow you to get that in, but it's certainly easier if it's within the crimes that are charged. It also helps you put together the real picture of the violence that this victim has faced. And again, this little chart is very simple, but oftentimes, as Colleen was mentioning, people get these cases and they get very overwhelmed. Can they prove the elements? Do they even know the elements? And this is just a simple little tool to make sure that prosecutors know the elements of the law that they're trying to charge, and then break down the witnesses and the evidence that they actually have. And oftentimes when you do this, you determine that you have much more evidence than you otherwise thought that you did. Now, any one of the next topics that I'm going to talk about, again, is in and of itself an hour and a half, so this isn't going to be a thorough discussion of all of the in-depth prosecution tactics, just a highlight of some of the common prosecution issues and some resources and information to help you overcome them. So again, these cases are, they are the victim plays a role and has information to give in these cases, but they don't have to be totally victim dependent. And particularly when a victim is unavailable or uncooperative, it doesn't mean that the case cannot go forward. I'm going to tell you that it's very hard, and you're not going to be able to go forward in every case. However, there are several tactics and several, legal issues that come up a lot in the domestic violence world, less frequently in the sexual violence world because of the importance of having the victim testimony in adult sexual violence cases. But nevertheless, there are areas where we can go forward without a victim's cooperation. And again, I'd ask you, we have resources at AEquitas to address this. The one legal issue I want to raise, the first one is Crawford. And this is Crawford and its, progeny are a line of cases that deal with the admissibility of a victim's statement that was made outside of court, the admissibility during a trial where that victim is unavailable and they're obviously not in court testifying and there hasn't been a prior opportunity to cross-examine them that the court is satisfied with, or there may not have been a prior opportunity at all to cross-examine. And there, when you look at the cases and the way they've been analyzed, not all of these statements are inadmissible. And again, it's important to look through this resource because in, a very quick summary, in essence, if the statement is made for the purpose of, reporting an ongoing emergency, it can be admissible. And there are tools and ways of analyzing the statements to determine if it can come in. More relevant, I think, is, and related to Crawford, is this issue of forfeiture by wrongdoing. And this is so tightly knit to witness intimidation, which we spent some time talking about. Witness intimidation in human trafficking and other crimes is prevalent. And the tactics with which perpetrators use to intimidate witnesses are very subtle and had been overlooked for a long time and continue to be overlooked, although communities are getting better at it. But forfeiture by wrongdoing is a tool in the rules of evidence and in case law in some jurisdictions, but it exists in all jurisdictions, whereby if the defendant has, through his own wrong or her own wrongdoing, prevented the victim from being present and able to testify for the purpose of preventing their testimony at either the current case that's being litigated or some other case, a future case, if they did this wrongdoing before before charges were ever brought against the defendant, but you can prove that the wrongdoing was done to prevent the victim from being or this witness from testifying against the defendant, then you can admit that person's statements in. And again, this is very complex. We, spend hours on this topic alone, but we have resources. It's pretty simple in terms of how you analyze this information. And once you have proven that a defendant has engaged in this wrongdoing, and again, this conduct doesn't necessarily have to rise to the level of a criminal charge. It is something that can be very subtle, promises to change. I mean, there's several actions of a defendant that have been found to constitute forfeiture by wrongdoing. This can make an enormous difference in the kind of testimony that is admitted at a trial. The other issue that I want to, other rule of evidence that I wanted to bring up was, and it's related also to some of this wrongdoing, these are all related, is introducing other acts evidence. Now, this is a separate rule of evidence, Rule 404B under the federal rules, and every state has something different, whereby which the prosecutor can introduce evidence of a defendant's other acts, usually other bad acts, as so long as they're not just proven to show that he or she is a bad person, but they might be brought in to show motive, they might be brought in to show intent, lack of mistake, and so when you're looking again at the charging of these other crimes, when you're looking at a perpetrator's history, it's important to think of this. And the critical piece is the other acts that the prosecutor brings in, they might be charged or uncharged conduct. In some jurisdictions, they can include acquittals. So it's important to really get a full and comprehensive understanding of what this perpetrator has done and to analyze whether or not that evidence is relevant and will come in. The second area where And again, the reason I said it was relevant to forfeiture by wrongdoing is because some of that evidence, the other act evidence, might be evidence that comes in this forfeiture by wrongdoing hearing, whereby we're trying to get in a victim statement by showing bad acts that the defendant has done to prevent that victim from testifying. Another area where that defendant's wrongdoing may also be admissible in the case in chief is by establishing consciousness of guilt. And again, really looking at the case law and the rules surrounding how to admit that. But you can be able to show not only why your victim isn't there, but you can show this, introduce this wrongdoing to show that the perpetrator has a consciousness of guilt. Another area, because one of the identification barriers and investigation barriers that Colleen raised was immigration issues. And again, I'm not going to go into the what we have to demonstrate to obtain T and U visas for our victims, but the T visas are the visas for trafficking victims to allow them status when they're cooperating. And something to think about is that you may not, even if you can't prove that your victim is a trafficking victim, you may be able to obtain a U visa because there are other crimes that are covered under the U visa. And we've included a link with much more detailed information on what you need to establish in order to obtain a T and a U visa, and some resources and individuals who can, who can help assist the victims. But that'll overcome another barrier. And finally, it's, in terms of supporting the victims, getting the housing and supporting the investigations and the prosecutions and the advocacy that we talked about. There are, people have certainly done individual fundraisers, created nonprofits, have partnered up with corporations and other places to get this funding. But one area I wanted to talk about was in using asset forfeiture to obtain this. And in terms of asset forfeiture, it is, there's criminal asset forfeiture and civil asset forfeiture. Civil asset forfeiture is, quasi-criminal in nature, but you don't necessarily have to show a conviction. Every state has some sort of asset forfeiture. Now, the issue is not all of those states, some may be specific to narcotics and to other crimes. So the first thing you're going to have to do is really look at your state law and find out if it's a narrow asset forfeiture law that only covers particular crimes. But again, this is where making your charging determinations is very important, because if you have a human trafficking offender and they're engaged in other criminal activity, you're going to be able to, use those other charges in order to perhaps go forward on an asset forfeiture piece, which in essence will seize the assets. And again, we talked about how difficult it is and how a lot of these perpetrators, the lower level ones, don't appear to have a lot of assets. There's some, thought, are they using up the money? And a lot of us are very cynical about whether or not they're using up this money or whether or not it's just much more difficult. It's just been hidden very well. So again, this is where collaboration with financial crimes and others can really help to identify financial assets and then seize them to fund all of these initiatives that we've been talking about. And the final piece is restitution in terms for the victims. And again, you're going to want to check your state laws to see if you have this, and if you don't, you might want to look into whether or not laws should be developed. And if you do, you really want to think about getting restitution for victims to make up for all of the the medical expenses, lost wages, any out-of-pocket expenses. And, this is something that also can be asked for as part of a sentence in some cases. So you're really going to want to, sit down and look at the tools that you do have to see how you can make the victims whole. And I just want, I know we covered a lot of information and not a lot of it in depth. I want to make you aware that we have in-depth information at AEquitas, and I know that Colleen has it at the Urban Institute, and we really are here to help you work through these very difficult cases and to help you with your strategies and to where we don't know an answer or an expert or an issue to connect you with someone else who does. And just thank you so much for the work that you're doing.
And I'd like to echo Jennifer's thank you for all of your dedication to increasing victim safety and offender accountability in your communities and across the country. I'd also like to thank Jennifer and Colleen so much today for presenting. And just so you know, AEquitas is a 24/7 technical assistance provider, and we're available to respond to any of those questions, concerns, and training needs that you have. You'll notice the content link on iLink for this recording. You will be able to access the PDF copy of this presentation as well as the presenters' biographies and a copy of the Urban Institute report. Thank you all so much again for participating.